You're watching Single Process with Joe and Barb. We've created a series of videos to help you navigate the difficult process of divorce. We hope this helps you on your journey. Our episode today is on what your legal options are as you start the divorce process.
Yeah, I mean, this is Divorce 101.
What
should I do?
Well, I think everyone thinks they should mediate or they should collaborate, otherwise they're going to end up in a trial. I don't think that's necessarily the case.
No, I assumed I should litigate. You want to end up in a trial, right? That's
I don't know.
On television. I don't know. So luckily we
don't believe everything you see on TV.
I do though, Joe, I do. So luckily we have Eric Broder with us today. And Eric Broder is a founding partner and with the law firm Broder and Orland in Westport and Greenwich, Connecticut. He is a seasoned litigator with over 20 years of experience in family law. He also serves as a special master to the Superior Courts, which is actually a really big deal. So, Eric, thank you for being with us.
Welcome, Eric.
Thank you for having me. Really.
Yeah. So start us off with...
Break it down.
Yeah.
All right, I will. I'll do my best. So there are really three areas. There's mediation, which is a very, very popular buzzword now, collaboration, and then there's litigation. Mediation is great if it can happen, but I really find it sometimes to be an overused tool. I have a few rules that I like to get out of the way when dealing with mediated cases.
Okay.
First, both parties have to equally want to get divorced, and you'd be surprised how many actually don't.
That's
Oh my
not
gosh.
often the case.
No, that's not the case.
Right? Okay.
Or one maybe is conceding, but they're angry about it.
Yeah, or one wants to drag it out, or one doesn't necessarily want to, and one pulled the other to mediation.
Okay.
Again, not against their will per se, but it wasn't their first choice. They threaten maybe we don't have the money, the funds, we have to mediate. And the problem with that is if you wanted to stall out a mediation, come see me, I'll give you a million reasons. You don't feel well, we need to reschedule. I didn't get all the documents together.
Right, you can just procrastinate and
put
drag
it
it out.
And off. And there's no clock in mediation because you don't have the court overseeing your cases. And I can speak to Connecticut where cases should take approximately a year.
But the courts want it off their docket, so there's that timeline.
But not everyone usually files when they start mediation, so the timeline doesn't exist.
Okay.
So that's the first rule. The second rule is relatively an equal understanding on finances. At least both people should be conversant in what they have, how they earn income, right?
Why did I mediate?
Right. Well, if people say that, I mean, some people don't know what are stock options. Or my husband is, for example, a business owner, and how are things paid for, what personal expenses they've run through, how that gets imputed as income. These are concepts that you should have an understanding of, or at least align yourself at the very, very beginning of mediation with a lawyer or an appropriate business valuator.
This
or
is
a
review
professional.
counsel you're talking about.
Yes, but
right?
review counsel, in my view, should start in the beginning. They should be coaching you in the background. Coaching is really a better word than review counsel. That'll help guide you there. The worst thing I see, and I see it sometimes, people come to me and say, here's my agreement, take a look at it. And I look at it. And my job isn't to blow it up. It's to make sure, things are going to get done. I sort of call it the, oh my God statement. If I see that in there, then I know, or something in the agreement, I know I better do something. And short story, somebody once had said to me, well, my husband is keeping all the stock options because they're not worth anything, he told me, because they're underwater.
He told me.
He told me at mediation, and he has to still work there. But if you looked at their asset portfolio, the options that he was going to receive in the next year, 2 and 3 years, were a substantial portion of their assets. But she, in this example, had no idea. And I got this at the very end, so now I was the bad guy.
So now that's an oh my God moment.
That was an oh my God.
Counsel for this mediation. Okay,
Yes.
so that stuff happens. Okay.
So that's another way of looking at it. Also, and maybe should have said this first, there should really be no major issues concerning the children. If we're dealing with maybe an overnight or after school activity, that's one thing you should and probably could mediate. But if there's major issues on custody or parenting, then mediation is not for you. That actually should be handled with a professional, a therapist, a family therapist. Work with someone who, A, knows a lot more about family issues than a divorce lawyer, and B, who will be there when the case is over. When the case ends, the last person you probably want to be calling is your divorce lawyer. We're not a sign of a good memory.
we don't want to keep you guys going.
People don't tend to reach out to us to share all the news necessarily, but what you want to do is get a therapist who can maybe meet with you, with your husband, and sort of referee issues. Far less expensive and far more qualified. Okay. So those are sort of the qualifications to get into mediation. If you can check those boxes, then certainly try and mediate
Give
your
it
case.
a try. We should not have
Give it
been
a
in
shot.
that box.
That's an
Barbara.
awesome summary. I know, completely agree. Because I think it's overused today. I think people rush to it thinking it's less expensive, it'll be done faster.
And to that point, if a mediation blows up, some of the worst cases we've had in our office are people that thought they could mediate, invested 6, 7, 8 months in the process, and then it blows up. You can imagine the trust that they thought they had to mediate is gone, and now we have usually a horrific, potentially horrific litigation.
And you've tipped your hand on where you stand on certain things before you
Yes,
get your own
true too.
representation, right?
True.
That's true too.
All right, so what's
Okay.
collaboration? Take us through that one.
Briefly, collaboration is somewhat of a mediation with your lawyers involved, where each party has a lawyer and all four participate together collaboratively to work on resolving the case. It's formal collaboration. Neither party would go to court or file anything with the court, and if they do, they then have to essentially terminate their attorney, because the attorneys sign an agreement that says we're going to collaborate, and if it blows up, we're out of the case.
Oh, you have to start over with different attorneys.
Right. So there are a lot of positives to collaboration. If you can sit down and work it out together, absolutely, it's great. The somewhat critical drawback that some people will say is, I just spent 6 or 7 months with this lawyer. We've tried to collaborate. We failed. And now I have to start over and find a
From
new lawyer.
scratch. That sounds absolutely awful.
But at least in this case, like, your interests are represented. You've got someone you feel like is on your side.
Absolutely.
Not that mediation does that too, but you don't feel it maybe.
You have someone in the room with you, which is quite
Yes.
helpful. So it does have a benefit. The drawback to a lot of people is a collaboration. If it ends, the lawyer's out of the case. And if you spend 6, 7 months getting to share your story, and as a lawyer, that's probably where I know someone's case the best. I've seen them go through up and downs through the divorce process. After you've known someone 5 or 6 months through good and bad moments, and you learn a lot about them, that's sort of the sweet spot and helps you figure out the next phase of the case. So you have to start over. And
That's like having to give up your therapist.
Yeah,
I
it
couldn't
is.
imagine. Not that you guys want to be therapists, but it sounds like the same thing. It's a
Expensive
therapist.
therapist. Really?
so that yeah. I always joke that we play therapists at work. So
You do.
So we try not to. We want to be attorneys, but that's where collaboration can be a problem if it breaks down. A lot of lawyers, I mean, myself, my office, we try to work collaboratively with the other side. I mean.
But that's different from a formal collaborative process.
Yes, I think the word collaborative still applies. I mean, I joke it's like the Chinese food, the circle where you pass it around the table that way. I might represent the husband, business owner today, but my next case I represent maybe a stay-at-home mom. So I could flip sides easily with the other lawyer because we know what the other one's going to do.
You've got perspective.
So just give them all the information they're entitled to. Don't play games. Get it on the table. And see if you can resolve
That's something I would underestimate. Your relationship with other attorneys probably factors in hugely as to how you resolve things.
It does, tremendously. In fact, when I always asked, how long will this case take? How much will it cost? I hate answering a question with a question.
Yeah.
Who's the other lawyer? And there are some lawyers with one case I can.
He's a rat bastard.
Yeah, well, yes. I mean,
We don't say that about anybody,
it's a family
Barbara.
show,
Puzzle
right?
thinking.
I don't say that either. I'm not telling you what I always think. But we know. I mean, I can tell you over a cup of coffee or a dinner, can settle a case. I once settled a case in crayon at a restaurant where they had, for the kids, the crayon and the paper tablecloth, and we did math. And by the time dinner was over, we had settled the case, the lawyer and I. So that same case, though, with another lawyer could take 18 months in court, litigation, and tens of thousands of dollars. So it really depends on the lawyers involved. And some lawyers won't work even collaboratively in an informal collaborative setting.
Okay. And so now move on to what people think of as an adversarial divorce or litigation. Does it have to be, just because I hire my own lawyer and don't mediate officially, does it have to be an acrimonious process?
No, and the biggest sort of misnomer out there is that cases go to trial all the time. I mean, if 2 or 3% of divorce cases go to trial, that would probably be a relatively high number.
Why does something even go to trial?
Oh, there are a lot of reasons why things go to trial.
Yeah.
Some people just want to have a trial. They want their day in court. They want somebody to make a decision for them. They're incapable sometimes of reaching a settlement agreement. So I've had cases where I say, just tell me what you want, write it down, sign it, and we'll sign it. And people are incapable of doing that.
They just can't do that.
They just can't do it. Some people don't want to let go and get divorced.
Yeah.
So you have to get to that point. But litigation is a really broad word. People are scared of it, but shouldn't be. Cases start off in a litigated fashion, and we settle them. We settle them all the time. We settle them 2 months in, 6 months in. Sometimes on the doorstep of trial, we settle them. A few times, I once completed a trial, and after 4 days of trial, the other lawyer and I sat down, and we settled the case before the judge had a chance to write his decision.
My perception is it's contentious. The minute you say litigation, it implies negative, fighting, or no?
And it does to some people. It shouldn't, and it's not always the case.
Okay.
Because in litigation just means you filed an action, now you're under the court system, and that's it. And you're exchanging information and learning things. But absolutely, it does not have to be a contentious case. Trial is really, I mean, I like trying cases. I'm trained to. Fun is not it's a skill that we have, and you get to focus on one case. There's an advantage as an attorney when you're busy to have one case one day to focus on. You can do cross-examination, all these things you learned how to do in law school. But it's actually stupid for clients to go to trial, frankly.
Really?
You're spending a lot of money.
A lot of money.
Okay.
And you're asking...
This is a full day in court.
Yeah.
And you're asking a person in a black robe who's going to know you for what, a day? Not even a day, a few hours of testimony to make a decision that's going to impact your and your children's lives forever. And in the state of...
Sorry, Eric, I hear oftentimes that you can't predict what a judge is. I mean, the judges, it can come and go.
That's right. And you don't know, I mean, as much as we like to think we know about the judges, you may be involved in a case where one spouse has a real drinking issue and can't seem to recover. And maybe that judge's son had a really bad divorce from a woman who had a really bad drinking issue, and the judge has some personal, not bias, I don't mean, but understanding or perspective. Yeah, or the other way around. So you don't always know. And these judges, the story I like to share is there were 2 judges who are no longer trying cases.
It usually starts with 2 judges walk into a bar.
Yes, 2 judges walk into a bar. That's right. These 2 would have been interesting to see in a bar, actually. And one judge said to me once, I try cases and try to be predictable so everybody knows what I'm going to do, because that'll deter people from trying them, because they'll go, oh, if I'm in front of this judge, I know how he's going to... The outcome. The other judge said, I'm all over the place, and I'm intentionally inconsistent and erratic within the law because people will be scared to come in front of me because they don't know what they're going to get.
I like that.
And if those 2 judges literally sat one door apart, and in certain states, in Connecticut, you don't know your judge until the day of trial. You walk in and they say you're going to courtroom
There's no
1.
trial strategy here.
So you don't know who your judge is going to be.
Wow.
But overall, litigation is not as scary as a word, and it shouldn't be as scary as a word. And most cases do settle somewhere within the pattern and path of litigation. And if they go to trial, you're letting someone else decide. And I'll point out one important thing. Nowadays, decisions they're on the internet. And judges will write, the husband claimed that the wife had an affair, had a drinking issue.
Putting everything out there.
The wife claimed the husband was not an involved father, only cared about work, and was having an affair. The judge might write those things down and say, I find neither party to be more persuasive than the other. But guess what? That's
All
online.
out there.
Yeah.
Their kids are going to read this decision. The next date they're going to go on, I am sure that someone going on a date, if they know their date is divorced, is going to Google them and find that information. And now it's all out there. Their kids' friends. I mean, and it doesn't go away. To get a file 20 years ago, you had to go to some building and you had to go to some dusty old
Locked in
room,
storage.
and it took 3 weeks, and you had to pay $1 a page to get copied, and God knows. Now
I'm not old enough to know about that.
right, you wouldn't know. I'm just sharing.
No, but I've heard.
I'm just sharing the horror, the basement of some of these courthouses. Yeah, and now it's just click, click, click on your phone. You can play Words with Friends and look up your next date. So
If one person wants to get divorced and the other one doesn't,
I think all states now have no-fault divorce. And there are times where literally one person wants to be divorced and one doesn't. And even at the divorce, the person says, I don't want to be divorced. But the judge says, I'm sorry, if one wants to be divorced, you're divorced.
Go ahead.
Okay.
All right. Well, this has been so
Enlightening.
helpful in terms of lining up your options.
I'm going to go back and get divorced again. I'm going to do it a little different.
No do-overs.
No do-overs.
No do-overs.
Eric, thank you so much for joining us today.
You're welcome.
So
Thank
for
you.
information on this topic and more, please visit us at singleprocess.me.